All right, moving on to Form 220. As you can see, there's a lot of yellow on this form. The old Form 220, even the title didn't survive. So, this was a form that got some substantial editing and rewrite. So let's go ahead and go through it and how it fits into your practice going forward with these new MLS rules. So first of all, we tried to make the title a little bit simpler. This is the Confirmation of Compensation Agency and Appointment Form, formerly, and now it is the Cooperating Compensation Agreement. And this form in the past is something you may have used, like if you wanted to make an offer outside your MLS, in another MLS that you were not a participant in, then you may have used this form to make an agreement with the listing agent to be able to get cooperative compensation in that MLS, because that cooperative compensation would have been offered to you if you were not a participant in that MLS. So this was the form you would use for that, not an unrepresented seller. That would have been Form 150, the unrepresented seller compensation form. So that's not the actual title of it. So don't look it up that way. But in any event, if I had it in front of me, I could give you a specific title, but that is the unrepresented seller confirmation agreement. You can make an agreement with the seller for a cooperative compensation with that form. In any event, if you look here at the top, there's a note. Use this form to create an agreement for cooperating compensation if a seller is represented by a licensed real estate agent. Use Form 150 instead if you got an unrepresented seller. And then finally, and probably pretty importantly, do not upload this form to the MLS. Okay, compensation simply is not going to be part of the MLS going forward once the new rules take effect. So this has all been deleted. So delete, delete, delete. Okay, this is all going away, and then we're starting with seller, buyer, and property. Okay, just like a lot of the different forms, and then we have the fee in paragraph 1. And who is the fee going to be paid to? It's going to be paid to the buyer agent's firm, okay? But it can be paid by, if you look at the check boxes, either the seller or the listing firm, okay? So we have the selling firm, which is defined down here, okay, in these signature boxes. So don't feel like it needs to be up here. It's already defined down below. We tried to keep this as simple as possible, okay? We want it to be simple but effective, all right? So seller or listing firm, either one. And it would be entirely possible to have two separate agreements in the course of a transaction. You could do, if the listing firm was offering one, you could do it with the listing firm. And if it turns out later in the transaction the seller wanted to offer more, then you could do that as long as the buyer agrees. Don't forget that part of this process. But it would be something where you may consider doing an agreement directly with the seller, just so that for ease of process, so that the listing agent doesn't have to go on the back end, do a bunch of amendments to their agency agreement with the seller to be able to accommodate cooperating compensation. It was something that we hope is useful. If it turns out to be a lot of confusion about it, then it might be something that the Forms Committee will have to evaluate as we go forward. But as an initial thought, it was thought that having the flexibility to be able to make an agreement with either the seller or the listing firm, or potentially both in two separate forms, then that would be helpful to you guys. So we will see how it works and then tinker it with it as necessary as going forward. So we got percentage of sale price, flat fee, or other. And it may well be you would check other and then have an attachment or addendum. You could say see attached or something like that. And mind you, this is an agreement between selling firm and seller, listing firm. This is something I have to tell people all the time in the hotline. But if you're drafting a document for yourself, so like agency agreements, most commonly, between the firm and the client, those agreements, you're not drafting them for someone else. It's not the practice of law. You are a party to that contract, and when you are a party to the contract, then you're not drafting it for yourself. If the other side agrees, great. So just understand that a lot of times it's still going to be advisable to have an attorney give you input on a particular form, or maybe an amendment to the form, or an addendum, or things like that. That is certainly the case. But if it's something where it's simple, you feel confident, and you want to draft it yourself, and then perhaps have a lawyer, review it to make sure you're not crazy, that's something you can do without running afoul of unauthorized practice of law rules. Okay. So, moving down to paragraph 2, payment of the fee. Much like the other agency agreements, the fee is going to be earned and then it's going to be payable. Okay. So those are two different things under most of the agency agreements and throughout the forms. It's hopefully something you guys are familiar with. A fee or a commission can be earned, but it may never become payable depending on the circumstances. So a common example that happens every day would be the buyer and seller going to contract with the standard offer to purchase a contract. The buyer terminates during the due diligence period. If you are the buyer agent or listing agent, the fee has been earned once the contract is signed, okay? But it doesn't become payable because there's no closing, there's not been a breach by the parties, there's nothing really there to trigger the earned commission to be payable, okay? And that's, how it is meant to work to be able to protect you guys, because your fee is earned, but then it doesn't become payable for one reason or another. Then you guys can be able to use these documents to be able to, if you need to, take someone to court. It's something that is an unfortunate circumstance, but that's what these forms are meant to do. These forms are not meant to stop people from acting poorly. Okay. There's simply not. There's nothing in the world that'll stop people from acting poorly. If anybody has the solution to that, feel free to reach out to me, and perhaps we can make a lot of money. But contracts are meant to make sure that if someone is acting poorly, then you can take them to court and enforce it. And it is something that I've done for clients in the past in private practice, and I can tell you firsthand that these forms work very well. And they are recognized as pretty strong legal documents. So I feel pretty confident in their ability to do that. Now, granted, this Form 220 and this revision is going to be brand new. While I feel confident about it, it's one of those things where it will need to be tested before I feel more confident about it. In any event, I feel confident about it to recommend it to you guys for your use. In any event, the fee will be earned by the selling firm when the buyer and seller sign a written contract, and the fee will be due and payable when the buyer or any authorized assignee of the buyer or any party authorized by buyer or anyone else to close on the purchase of the property. Okay? And the fee will be paid at closing as defined in the contract unless otherwise agreed. All right? So paragraph 2 sort of goes through and basically says, if everything goes good, then we're going to get paid at closing. All right? Great. So on to paragraph 3. This agreement shall be effective when signed by the seller listing firm as applicable, and then will terminate at the earlier of closing or a blank. Okay? So you're going to fill in that and actually put an expiration in there so it's not hanging out there forever, unless the fee has been earned. And so that is something that you're going to want to understand, that your fee may well be earned prior to the date. And if it has, then this next section is going to kick in. If the fee has been earned prior to the expiration of the date, then the agreement shall not terminate. This agreement, the agreement Form 220, shall not terminate and will continue to be in full force and effect until closing or until the contract is terminated, so long as the termination is not a result of the seller's breach. So basically, as long as as long as the fee has been earned, then the seller's not going to be able to just wiggle away their way out of Form 220 if they've signed it just by walking away from the closing table or something like that. That's really what this language is meant to do. Okay. And then finally, in paragraph 4 here, we have some lawyer mumbo jumbo. The most important part of the lawyer mumbo jumbo is that this agreement is the entire agreement and that anything outside of it doesn't exist. Okay? And if you want to change it, you got to do it in writing. So for some of you, this is going to be pretty important. Okay? Because it's not something where you're going to run past the fact that if the terms of this change, then you got to have some kind of writing to be able to evidence that. So just make sure that you do that, and you know, don't just be out there, having phone calls with people and saying, oh yeah, well, we'll change it to this, that, or the other, and then have a surprise at the closing table. You do not want that. Okay, you were talking about transactions that you guys are working very hard on. You're spending a lot of time on. You want to make sure that you are treating your compensation with the respect it deserves, at least in this context, to make sure that you're not doing things that would jeopardize your ability to get paid at the end of the transaction. And then, see, what will happen is once the strikeouts are cleared out in the final form, this will be a solid just page and a half. And then everything, all this stuff will be on the first page, and then the signature page will be on the next page. You can see we have 4 blocks here for seller, buyer, selling firm, and listing firm. Now, mind you, it may well be, depending on the circumstances, depending on what you check in paragraph 1, seller, listing firm, one of them may not be entirely necessary to the contract. Does that mean that the listing firm shouldn't sign? Not necessarily. I'm not sure there's one right way to do that. But what is important is that if compensation is agreed to, I think the most important thing is that the seller and the buyer, they are certainly mandatory no matter what. There can be a question as to the listing firm depending on if they've agreed to anything or not. But you can see here there's actually language that says buyer signs to acknowledge receipt of this form and consent to the fee arrangement. That's really important. Seller also needs to do that, especially if unless the listing firm has some kind of completely independent compensation agreement from the seller, which is very unlikely. So when it comes to using this form, it's going to be the primarily buyer, seller, and then selling firm, and then listing firm probably most of the time, but maybe not all the time. All right. So that's the new Form 220. We do hope it will be a valuable tool for you guys if you navigate the new landscape. We are going to cover one more form, Form 770.